On November 6, 2025, in a federal courtroom in Fort Worth, Texas, Judge Reed O'Connor made a decision that would send shockwaves to the aviation world and leave hundreds of grieving families feeling betrayed once more. He dismissed the criminal conspiracy case against Boeing, the case stemming from two catastrophic crashes that killed 346 innocent people. But here's what makes this story so infuriating. Judge O'Connor didn't dismiss the case because Boeing was innocent. Far from it. He dismissed it while simultaneously calling out the deal as failing to secure the necessary accountability to ensure the safety of the flying public. He accused the Department of Justice's reasoning as unserious and criticized Boeing's troubling history. Yet, his hands were tied by prosecutorial discretion. This is a story of how one of America's most iconic companies put profits over people, deceived regulators, killed 346 souls, and walked away without a single executive going to jail. It's a story about corporate greed, regulatory capture, and a justice system that treats white-collar criminals with kid gloves while claiming to serve the public interest. Buckle up. This is going to be a turbulent ride. It was supposed to be a routine one-hour flight from Jakarta to Pangkal, Indonesia. 189 passengers and crew boarded Lion Air Flight 610, a brand-new Boeing 737 MAX 8 that had only been in service for 2.5 months. The aircraft was so new, it still had that fresh-from-the-factory feel. 13 minutes after takeoff, at 6:33 a.m. local time, the aircraft plunged into the Java Sea at over 450 miles per hour. There were no survivors. Not a single one. The black box data would later reveal a horrifying picture. The pilots had been locked in a desperate battle with the aircraft's computer system. The plane's nose kept pitching down violently, again and again, as the pilots fought to pull it back up. They didn't know they were fighting a system they'd never been told existed, a system called MCAS. Fast forward less than 5 months. The 737 MAX was still flying, despite growing concerns from pilots worldwide about the aircraft's handling characteristics. Ethiopian Airlines Flight 302 took off from Addis Ababa International Airport, bound for Nairobi, Kenya. Captain Yared Getachew, a highly experienced pilot with over 8,000 flight hours, was at the controls. 157 souls were on board, passengers from 35 different countries, including aid workers, tourists, and families. 6 minutes after takeoff, at 8:44 a.m. local time, the aircraft crashed into a field near the town of Bishoftu. The impact was so violent that the wreckage was buried deep into the earth. Like Lion Air before it, there were no survivors. Among the dead was Samya Stumo, a 24-year-old American aid worker heading to meet her mother in Kenya. There was Pius Adesami, a renowned Nigerian professor and satirist. There were UN workers, entrepreneurs, children, grandparents, each with their own stories, dreams, and families who would never see them again. The similarities between the two crashes were impossible to ignore. Within 3 days, aviation authorities around the world grounded the entire 737 MAX fleet. All 387 delivered aircraft. 8,600 weekly flights stopped. The MAX will remain grounded for 20 months, the longest grounding in modern aviation history. But here's the question that haunts us. How did this happen? How did Boeing, a company with a century-long reputation for engineering excellence, produce an aircraft that killed 346 people in less than 5 months? The answer lies in a perfect storm of corporate greed, competitive pressure, and deliberate deception. To understand the 737 MAX disaster, we need to rewind to 2010. Boeing faced an existential threat. Airbus, its European rival, had just launched the A320neo, a re-engined version of the popular A320 that promised 15% better fuel efficiency. Airlines were lining up to place orders. Boeing had a choice: design a clean-sheet aircraft from scratch, which would take a decade and cost tens of billions of dollars, or retrofit their workhorse 737 with new, more efficient engines. They chose option 2. Speed to market over engineering prudence. But there was a problem. Actually, several problems. The 737 was originally designed in the 1960s. It sits low to the ground because airports back then didn't have the tall jet bridges we use today. Passengers climbed stairs to board. This low clearance meant that the new, larger, more fuel-efficient engines couldn't fit in the same position as the old ones. Boeing's solution? Mount the engines further forward and higher up on the wings. Problem solved, right? Wrong. Dead wrong. When you move heavy engines forward on an aircraft's wings, you fundamentally change how it flies. Specifically, in certain flight conditions, particularly at high angles of attack during steep climbs, the nose could pitch up more dramatically than on previous 737 models. This could potentially lead to a stall. Boeing's engineering team created a software fix, the Maneuvering Characteristics Augmentation System, or MCAS. This system would automatically detect when the plane's nose was pitching up too steeply and would automatically push the nose back down by adjusting the horizontal stabilizer. On paper, it seemed clever. In practice, it was a catastrophic design failure built on several fatal flaws. MCAS relied on data from only one angle of attack sensor, a small vane on the outside of the aircraft that measures how steeply the nose is pointing relative to oncoming air. Boeing had two of these sensors on the plane, one on each side, but MCAS only read from one at a time. When that single sensor malfunctioned, as it did on both doomed flights, MCAS received faulty data telling it the nose was pitched up dangerously high when it actually wasn't. The system then did exactly what it was programmed to do. It forced the nose down. Again, and again, and again. The pilots on both flights didn't know what was happening. They'd pull back on the controls to raise the nose, and the aircraft would briefly comply. Then MCAS would kick in again and force it back down. It was a nightmarish tug-of-war between human and machine, and the machine was winning. Here's where Boeing's actions crossed from engineering failure into criminal territory. Boeing deliberately kept MCAS a secret from pilots. When airlines purchased a 737 MAX, their pilots didn't receive new type ratings, the extensive training required for a fundamentally new aircraft. Instead, Boeing convinced the FAA that pilots qualified on older 737s could transition to the MAX with just a brief computer-based training module that took about an hour. Why? Because if the MAX required extensive pilot retraining, airlines would face massive costs and delays. They might choose the Airbus A320neo instead. Boeing couldn't let that happen, so they made a calculated decision: hide MCAS from the pilots. It wasn't mentioned in the pilot manuals. It wasn't included in training. Internal Boeing messages, later revealed by investigators, showed that Mark Faulkner, Boeing's chief technical pilot, boasted about jedi-mind tricking regulators into approving inadequate training materials. In another message, he explicitly told the FAA to delete references to MCAS from pilot manuals. Think about that for a moment. Boeing installed a system powerful enough to override pilot commands and crash an aircraft, and they deliberately hid its existence from the very people who would need to understand it to save lives. Even if pilots had known about MCAS, the system was designed in a way that made it nearly impossible to overcome once it activated based on faulty data. Each time MCAS engaged, it could move the horizontal stabilizer in 2.5-degree increments. It could activate repeatedly, with only a 5-second pause between activations. This meant that within seconds, MCAS could put the aircraft into an unrecoverable dive. The pilots had to diagnose what was happening, remember an obscure emergency procedure, one they'd never trained for because they didn't know MCAS existed, and physically overpower the system, all while the ground rushed up at them at hundreds of miles per hour. On Ethiopian Airlines Flight 302, the pilots actually did identify the problem. They followed the emergency procedure. They turned off the electric trim system that MCAS used to control the stabilizer. But by that point, the aerodynamic forces on the stabilizer were so great that the pilots couldn't manually crank the trim wheel back to a safe position. The flight data recorder captured their desperate final moments as they tried everything they could think of. They didn't stand a chance. Boeing didn't just hide MCAS from pilots. They systematically deceived the Federal Aviation Administration, the very agency charged with keeping the flying public safe. During the MAX certification process, Boeing provided the FAA with incomplete and inaccurate information about how MCAS functioned. Specifically, they downplayed how powerful the system was and the flight conditions under which it could activate. Early in development, MCAS was designed to operate only at high speeds and to make relatively minor trim adjustments. But as the MAX development progressed, Boeing engineers significantly expanded MCAS's authority. It can now activate at low speeds, precisely the conditions present during takeoff, and could make much larger trim changes. Boeing never informed the FAA of these critical changes. Why would Boeing do this? The answer is chillingly simple: money and time. A more extensive review of MCAS would have meant delays, additional testing, and potentially the very pilot training requirements Boeing was desperate to avoid. Each delay meant Airbus would gain more market share. Each additional training requirement meant airlines might choose a competition. So Boeing lied, not through ignorance or oversight, but deliberately and systematically. It's important to understand that people inside Boeing knew something was wrong. Multiple whistleblowers raised concerns about production quality, safety culture, and regulatory compliance. They were ignored, sidelined, or pushed out. Ed Pearson, a senior manager at Boeing's 737 factory in Renton, Washington, sent emails warning of a production environment so chaotic that employees were routinely exhausted and safety was at risk. He specifically warned that continuing production in such conditions could lead to a catastrophic accident. His warnings were sent months before the Lion Air crash. Nothing was done. After the crashes, more whistleblowers came forward describing a culture where meeting production deadlines trumped engineering concerns, where managers bullied employees who raised safety issues, and where cost-cutting measures compromised quality at every turn. This wasn't a company that made a mistake. This was a company with a broken culture, where profit superseded safety, and anyone who pointed out the problems was treated as a problem. By January 2021, the evidence against Boeing was overwhelming. Internal messages showing employees mocking regulators. Documents proving they'd hidden MCAS from pilots and the FAA. Flight data, recorders revealing the terrifying final moments of 346 people whose deaths could have been prevented. The Department of Justice charged Boeing with criminal conspiracy to defraud the United States. Specifically, Boeing was accused of conspiring to defraud the FAA's Aircraft Evaluation Group, the division responsible for evaluating pilot training requirements. Boeing didn't fight the charges. They entered into a deferred prosecution agreement, essentially a probationary period where they admitted wrongdoing, paid fines, and promised reform. If they stayed out of trouble for 3 years, the charges would be dropped. The deal included $243.6 million in criminal fines, $1.77 billion paid to airlines who suffered losses from the grounding, $500 million for a victims' compensation fund, implementation of a robust compliance and ethics program. Victims' families were outraged. No Boeing executives were charged. No one went to jail. The criminal fine, $243.6 million, represented pocket change for a company with annual revenues over $60 billion. It was less than the CEO's compensation package, but at least there was some accountability, some acknowledgement of wrongdoing, and Boeing promised to change. They didn't. Picture this. It's January 5th, 2024. Boeing's 3-year probation under the Deferred Prosecution Agreement is set to expire in just 2 days. The company is about to have its criminal charges dismissed and emerge relatively unscathed from the deadliest corporate crime in aviation history. Then at 5:07 p.m., Alaska Airlines Flight 1282, a 737 MAX 9, departed Portland International Airport bound for Ontario, California. On board were 171 passengers and 6 crew members. 16 minutes into the flight, at 16,000 feet, there was an explosive decompression. A door plug, a panel that fills a space where an emergency exit door could be installed, blew off the aircraft. The cabin pressure dropped instantly. Oxygen masks deployed. Personal belongings, including cell phones and clothing, were sucked out into the night sky. Miraculously, no one died. 2 seats next to the gaping hole happened to be empty. If anyone had been sitting there, they would have been sucked out of the aircraft. Captain Emily Whiprud turned the plane around and made an emergency landing back in Portland. Her skill and composure saved 177 lives that night. But here's the terrifying part. The subsequent investigation by the National Transportation Safety Board found that 4 critical bolts that were supposed to secure the door plug in place were missing. Not loose, not improperly installed, missing entirely. These bolts were never installed because of slipshod production practices at Boeing's factory. Workers had removed the door plug earlier during production to fix riveting issues, then reinstalled without the bolts. No one checked. The aircraft was delivered to Alaska Airlines and flew for weeks with a massive structural vulnerability. This happened just 2 days before Boeing's probation was set to end. 2 days before they would have gotten away clean. The Department of Justice had no choice. In May 2024, they formally declared that Boeing had breached the deferred prosecution agreement. The breach determination meant that the criminal charges could be revived, and Boeing could face prosecution for both the original conspiracy charge and the violations of the agreement. The Alaska Airlines incident wasn't just a random quality control failure. It was evidence of systemic problems that Boeing had promised to fix but hadn't. The company had committed to implementing a comprehensive compliance and ethics program overseen by an independent monitor. They had promised to reform their safety culture, to prioritize engineering over profit, to ensure quality control throughout their production process. The missing bolts on Flight 1282 proved those promises were empty. But here's where the story takes an even more frustrating turn. Despite declaring the breach, despite having clear evidence that Boeing hadn't reformed, the Department of Justice offered Boeing another deal. Not a harsher punishment, not criminal trials for executives, but another sweetheart agreement. In July 2024, the Department of Justice and Boeing reached a plea agreement. Under its terms, Boeing would plead guilty to 1 count of conspiracy to defraud the United States, pay an additional $243.6 million criminal fine, the same amount as before, invest at least $455 million in compliance and safety programs, be placed under 3 years of corporate probation with independent oversight, face sentencing at the judge's discretion, potentially including additional penalties. To many observers, this looked like déjà vu. Boeing would admit wrongdoing again, pay a fine that amounted to a rounding error in their financial statements again, promise to reform again, and avoid any criminal prosecution of executives again. The victims' families were livid. Paul Castle, a law professor representing families of the Ethiopian Airlines crash victims, called the deal a sweetheart plea deal that fails to recognize the gravity of the crimes committed. Nadia Milron, whose daughter Samya Stumo died on Ethiopian Airlines Flight 302, said, "These crimes are the deadliest corporate crime in U.S. history, and Boeing executives should be held accountable in criminal court." The families have been advocating for real accountability. Criminal trials for responsible executives, a criminal fine of $24.8 billion, roughly 10% of Boeing's 2018 revenue, calculated based on federal sentencing guidelines, and an independent corporate monitor with real teeth. Instead, they got another slap on the wrist. But then something unexpected happened. Judge Reed O'Connor, the same judge who would eventually dismiss the case, refused to rubber stamp the plea agreement. In a hearing on July 24, 2024, Judge O'Connor expressed deep skepticism about the deal. He questioned whether the proposed fine was adequate, whether the compliance monitor would have sufficient independence, and whether Boeing's board diversity provisions, including the deal, were appropriate or even legal. He noted that victims' families had not been adequately consulted about the agreement, a violation of the Crime Victims' Rights Act. He pointed out that the DOJ's reasoning for the lenient term seemed unserious, given Boeing's history and the magnitude of the harm caused. Judge O'Connor rejected the plea deal and ordered both parties to renegotiate. For the first time in this entire saga, someone in a position of power was pushing back against the preferential treatment Boeing was receiving. The victims' families felt a glimmer of hope. Maybe, finally, there would be real accountability. For months after Judge O'Connor rejected the plea deal, negotiations continued. The victims' families hoped for stronger penalties, criminal charges against executives, meaningful reforms. What they got was worse than before. In May 2025, the Department of Justice announced that they had reached a new agreement with Boeing, but this time it wasn't even a plea deal. It was a non-prosecution agreement. Let that sink in. After 346 deaths, after systematic deception of regulators, after breaching their previous probation, Boeing wouldn't even have to plead guilty to anything. Under the non-prosecution agreement, Boeing would pay an additional $1.1 billion, combining a $350 million criminal penalty with $750 million for safety and compliance improvements. Submit to 3 years of independent monitoring. Make regular reports to the Justice Department about safety improvements. In exchange, the DOJ would drop the criminal case entirely. No admission of guilt, no criminal conviction, no trials, no executives held accountable. Boeing's general counsel, Susan Schwab, released a statement saying the company was pleased to reach this resolution and that Boeing remained committed to safety and quality. The victims' families were devastated. They immediately filed objections, arguing that the agreement violated their rights under Crime Victims' Rights Act, that it failed to serve justice, and that it sent a message to corporations that they could kill hundreds of people and buy their way out of accountability. On November 6, 2025, Judge Reed O'Connor held a hearing to consider the non-prosecution agreement and the family's objections. In a remarkable 26-page opinion, Judge O'Connor eviscerated both Boeing and the Justice Department. He wrote that the agreement fails to secure the necessary accountability to ensure the safety of the flying public. He noted Boeing's troubling history of safety failures, quality control problems, and repeated violations. He pointed out that the company had breached its previous agreement just days before it was set to expire, suggesting either willful disregard for their commitments or such profound systemic dysfunction that they couldn't fulfill them even when trying. He called the Justice Department's reasoning for the lenient deal unserious and suggested that the DOJ had not adequately considered the magnitude of crimes or the need to deter future corporate misconduct. But then came the gut punch. Despite all these criticisms, despite recognizing the deal's inadequacy, despite acknowledging the victims' valid concerns, Judge O'Connor dismissed the case. Why? Because of prosecutorial discretion. Under the American legal system, prosecutors have broad discretion to decide whether to pursue charges, what charges to file, and what plea agreements to accept. Courts have very limited authority to override these decisions, particularly when it comes to non-prosecution agreements, which aren't technically court proceedings at all. They're contracts between the government and the defendant. Judge O'Connor explained that while he found the agreement deeply flawed and inadequate, he couldn't force the Justice Department to prosecute a case they had decided not to pursue. His role was limited to ensuring that the family's rights under the Crime Victims' Rights Act were respected, and while those rights gave families a voice in process, they didn't give them veto power over prosecutorial decisions. This court is bound by the limits of its authority, O'Connor wrote. While I find this resolution profoundly inadequate given the gravity of Boeing's conduct and the catastrophic harm inflicted on 346 souls and their families, prosecutorial discretion lies with the executive branch. The case was dismissed. Boeing walked free. Again, in the courtroom that day, you could hear crying. Family members who had traveled from around the world, who had spent 6 years fighting for justice for their loved ones, sat in stunned disbelief. Nadia Milron, Samya Stumo's mother, addressed reporters outside the courthouse. My daughter didn't get justice. The 345 other people who died didn't get justice. This sends a message to every corporation in America. You can kill people through negligence and fraud. And if you're big enough, if you have expensive enough lawyers, you can buy your way out. Michael Stumo, Samya's father, added, Boeing executives made decisions they knew could kill people, and they made those decisions anyway because it was profitable. Not one of them will spend a day in jail. Not one of them has even been charged with a crime. How is that justice? Paul Castle, the attorney representing many of the families, filed a notice of appeal within hours of the dismissal. We will fight this to the highest court in the land if necessary, he said. The Crime Victims' Rights Act was passed to give victims a voice in the criminal justice process. That right means nothing if prosecutors can simply ignore victims' interests and courts can't do anything about it. But legal experts are skeptical about the family's chances on appeal. Prosecutorial discretion is one of the most protected powers in the American legal system, and appellate courts are extremely reluctant to interfere with it. The Boeing case isn't just about one company and 2 crashes. It's a window into a much larger problem. The inability or unwillingness of the American criminal justice system to hold powerful corporations and their executives accountable for criminal conduct. Consider these statistics. Since 2000, No executive of a major U.S. corporation has been criminally prosecuted for corporate misconduct that resulted in deaths. During the 2008 financial crisis, which destroyed millions of lives and nearly collapsed the global economy, not a single major Wall Street executive was criminally charged. The opioid epidemic, which has killed over 500,000 Americans, has resulted in massive civil settlements, but virtually no criminal prosecutions of executives. Corporate crime costs the American economy an estimated $300 billion to $600 billion annually, far more than all street crime combined, yet receives a tiny fraction of law enforcement resources. The pattern is clear. Corporations can commit fraud, violate safety regulations, even cause deaths, and as long as they're willing to pay fines, which are often tax-deductible and far less than profits from the illegal conduct, they can avoid any real consequences. Why does this happen? Several factors contribute to this. Major corporations can afford the best legal representation money can buy. They can afford to drag out investigations for years, to file motion after motion, to make prosecutions so expensive and time-consuming that the government often settles for a fine rather than going to trial. The Boeing case perfectly illustrates this. The company spent millions on legal fees, hired former government attorneys who understood exactly how to negotiate with their former colleagues, and had the resources to wait out prosecutors who were juggling hundreds of other cases. Prosecutors are often reluctant to be too aggressive with major corporations because criminal convictions can have ripple effects throughout the economy. Boeing is one of America's largest exporters, employs over 170,000 people, and is critical to national defense. A criminal conviction could affect its ability to secure government contracts, potentially threatening jobs and national security. This creates a perverse incentive. The bigger and more important a corporation is, the more it can get away with. Corporations are legal entities separate from the individuals who run them. This means that even when a corporation is held liable for wrongdoing, the executives who made the decisions that led to that wrongdoing often escape personal accountability. In the Boeing case, we know from internal communications exactly which executives knew about MCAS, which ones decided to hide it from pilots, which ones pressured the FAA to accept inadequate training. Yet none of them have been criminally charged. If we want to prevent another Boeing, another Purdue Pharma, another Enron, we need fundamental reforms. The single most important reform would be making it clear that executives who knowingly endanger public safety or commit fraud will face criminal prosecution and jail time. No more hiding behind a corporate veil. The Park Doctrine, a legal principle established in United States versus Park, 1975, already allows for criminal prosecution of executives who have a responsible relationship to violations, even without proof of direct knowledge. But this doctrine is rarely applied. If Boeing executives knew they could go to prison for hiding MCAS from pilots, would they have done it? Almost certainly not. Corporate fines need to be large enough to actually deter wrongdoing. Currently, they're often treated as a cost of doing business. The $243.6 million fine Boeing paid represented less than 0.4% of their annual revenue. For context, if you make $50,000 a year, a proportional fine would be $200. Would a $200 fine deter you from committing a crime that could net you millions in profit? Fines should be calculated as a percentage of revenue or, even better, as a multiple of the profits generated from the illegal conduct. In truly egregious cases, courts should have the power to impose structural reforms that actually change corporate behavior. This could include replacing the board of directors, installing independent monitors with real authority, breaking up companies that are too big to fail, requiring publication of internal safety reports and whistleblower complaints, mandating independent safety committees with veto power over production decisions. The FAA, like many regulatory agencies, has been systematically weakened over the past few decades. Budget cuts, industry-friendly appointees, and a philosophy of self-regulation have left it unable to effectively oversee the industries it's supposed to regulate. The FAA allowed Boeing to essentially certify its own aircraft through a program called Organization Designation Authorization, ODA, where Boeing employees acted as FAA representatives. This is like letting students grade their own exams. We need to rebuild regulatory agencies with adequate funding, staffing, and authority to actually do their jobs. As we close this investigation, let's remember that behind all the legal maneuvering, the corporate strategy, and the government failures, there are 346 individual human beings whose lives were cut short. There's Samya Stumo, 24, who wanted to help people in developing countries access health care. She'll never get that chance. There's Melvin Mose Odieno, a journalist and father of 3, who was heading to a conference when Ethiopian Airlines Flight 302 went down. His children grew up without him. There's Dita Indasari, a 27-year-old Indonesian who had just gotten engaged and was flying on Lion Air Flight 610 to meet her fiancé's parents for the first time. There are 343 more stories just like these. Parents, children, friends, lovers, dreamers. All gone because Boeing chose profit over safety and because our justice system chose corporate interests over accountability. The 737 MAX is flying again now. Boeing says it's safe, that all the problems have been fixed. The FAA has recertified it. Airlines are buying them again. Maybe it is safe. The MCAS system has been redesigned. Pilots now know it exists and receive proper training. Redundancy has been built into the system, so a single sensor failure can't bring down an aircraft. But here's the uncomfortable truth. It's only safe because 346 people died, and their families refused to let their deaths be swept under the rug. It's only safe because journalists investigated, because whistleblowers came forward despite the personal costs, because victims' families fought in court for 6 years, even when the system seemed designed to shut them out. The question is, what about the next Boeing? What about the next pharmaceutical company that puts profits over patient safety? What about the next financial institution that takes reckless risks with the global economy? Will we need 346 more deaths before we act? 500? 1,000? Or will we finally decide that in America, nobody, not even a powerful corporation, is above the law? This investigation is dedicated to the 346 souls lost on Lion Air Flight 610 and Ethiopian Airlines Flight 302. May their deaths not be in vain.